and welcome back to another Bailiwick Legal Facebook Live. My name's Danielle and I'm an Associate Solicitor at Bailiwick Legal. Today and over the next couple of days I'm going to be talking to you about wills and estates. So today's seminar is going to be on dying with a will. I guess just as a preface, the contents of this presentation does not constitute legal advice. It's only intended to be general information in summary form only and may or may not apply to your specific situation. So starting, I guess, it's important to note that 50% of Australians actually don't have a will. And they die without a valid one, which to me is a shocking statistic given that a will is a pretty common document that a lot of people know what it is. For those that don't know, a will is a legal document that sets out your wishes regarding the distribution of your estate when you pass. It also sets out the care of any minor children if you pass, leaving children under 18. And if you do not want to distribute to certain people, it sets out why you do not wish to do so. There are many good reasons to have a will, and these include you can be clear about who gets what assets. So you may have specific jewellery or items that you would like to leave to specific people, and you can decide how much, so when we're talking about money and assets of those natures. You can also keep the assets out of the hands of people that you do not want them to go to, like an estranged child. You can identify who should have custody of your children if they're underage. The beneficiaries of your estate will be entitled to the assets in a quicker and a faster way, and it can also work to save taxes on your estate as well. A badly written will can not only lead to delays and disputes, but it can also be deemed invalid. Wills must be in writing. They must be witnessed by two independent witnesses, and the will maker must be of sound mind when they make and sign the will. So when you're making a will, it should include your full name, address and occupation. The will must be clearly dated. It should include the full name and address of your executor, the attestation clause, which is the signing clause. You should never attach or pin anything to your will, never erase or amend in handwriting any part of your will, and you should keep your will in a safe place and be sure that your executor knows where it is. So in your will you may leave any part of your property, including personal items, as we discussed before, like jewellery, real estate or other amounts of money to particular people. And whilst it's not necessary to list every single item that you own, your will must deal with all of your property. So the best way to do that is to use expressions like all of my property of whatever kind, or all of my remaining property. So this way, if you don't want to set out every single item that you have, which is pretty common, then you can make sure that your will encapsulates everything that is in your estate at the time of your passing. And then you should also deal what happens with all of that property. So typically people sort of say, you know, if they've got specific gifts, they might deal with those first, and then they might leave their residuary estate to remaining beneficiaries. Typically wills will include the executor, so that's the person who will look after your estate and distribute it according to your will. So they will have the responsibility of collecting all of the assets and all of the debts, paying out the debts, and then allocating the assets in accordance with the will. They will also arrange the guardianship of minor children. And your will also set out any specific gifts, what you want done with the residuary of your estate, the passing of any controlling positions in any trusts or companies, any exclusions, so if you've got estranged children or other beneficiaries that you wish to particularly exclude. We also include, whether or not you want to donate your organs, and if you have any particular burial or funeral instructions. And whilst not necessary, it can be very helpful. Some other things to consider when making a will are superannuation and tax. So superannuation and life insurance do not actually automatically form part of your estate, and these are considered to be separate assets that you hold. So your superannuation is held in a trust and it's managed by the trustee of that fund, and this could be by way of a self-managed super fund, or it could be by way of a industry super fund. The trustee then determines who your entitlement is distributed to when you pass. So most funds will have an option of you doing a death nomination, and this will enable you to elect who you want to benefit from your superannuation or your life insurance when you pass. And there are different types to this. So there's binding and non-binding. Binding meaning the super fund trustee has to act in accordance with that nomination, and then non-binding, which means it's at their discretion. And then there's lapsing and non-lapsing. So lapsing, you have to renew it every 3 years, and non-lapsing, you don't have to redo it. So we strongly recommend that in addition to doing your will, that you also make sure you have a binding lapsing or non-lapsing death nomination in place. But we do also recommend that we put a clause in your will that deals with your superannuation in the event that the super fund trustee does pay the benefit into your estate. Otherwise, as I said, superannuation is held separately to your estate, so it doesn't automatically form part of those assets. Tax. In Australia, there's typically no inheritance or estate taxes, but there may be tax implications if the executor of your will resides outside Australia, and this is because the tax residency of the executor determines the tax residency of the estate, or if your beneficiaries reside outside Australia. So obviously our laws wouldn't apply over there. And then beneficiaries may have tax obligations for assets they inherit. For example, once assets are disposed of, so if they inherit a property, they may not pay tax when they inherit the property, but when they sell it, capital gains tax may apply, for example, or for income derived from assets. So for example, any income tax for dividends from shares or rent from any property. Once someone passes away, typically the executors will have to get what's called a grant of probate from courts, and this is just formalisation that the executor has been appointed into that position and that the will is valid. The Supreme Court of Western Australia deals with grants of probate in our jurisdiction, and an application can be made any time after 14 days from the death of the deceased. There are certain circumstances in which you may not require a grant of probate, and those are if the deceased owned real estate at the date of death as joint tenant with the other proprietor, and in those circumstances it automatically goes to that other proprietor. Another example is if they have bank accounts that also were jointly held with other partners or other persons, and again in those situations those bank accounts would just automatically go to those other persons. If the deceased didn't have any property and they only had personal possessions, or if the only property left by the deceased was a vehicle, then those are situations in which a grant of probate may not be required. So that's a little bit of a rundown on what happens when you pass away with a will. As I said, it's very important that you do have a will, and if you are one of the 50% that don't have a valid will, we recommend you get in contact with us. I hope that was informative and you got something from that, and feel free to jump on at the same time tomorrow where we'll be discussing what happens when you pass without a will. Enjoy the rest of your day.